You sell your car. The buyer hands over a check, takes the keys, and drives off. Later, the check bounces. The fraudster is a fraudster. Before you even realize you have been scammed, the fraudster flips the car, selling it for cash to a completely innocent third-party buyer who has no idea it was stolen. The fraudster then disappears. We are now left with two completely innocent parties, you, the original owner, and the new buyer. Only one of you gets to legally own the car. The answer to who wins depends entirely on the legal status of that initial transaction with the fraudster. This brings us to the legal doctrine of mistake. In everyday conversation, making a bad deal or being tricked feels like a mistake. In contract law, the word has a remarkably strict, restricted meaning. It requires far more than a lapse in judgment. To succeed, a legal mistake must meet two precise conditions. First, the error must make the contract physically impossible to perform, or radically different from what was anticipated. Second, the mistake must precede the actual formation of the contract and have induced it. The exact classification matters because of the remedy. If the fraudster merely lied to you, a misrepresentation, the contract is only voidable, meaning title can still pass to the innocent third party. But if you can prove a strict legal mistake, the contract is void ab initio. It is treated as if it never existed. Proving a contract is void for mistake is the ultimate legal maneuver to recover lost property, completely bypassing the rights of any subsequent buyers. But it is notoriously difficult to establish in court. We start with common mistake, sometimes known as shared mistake. This occurs when both parties make the exact same fundamental factual error at the moment of contracting. To see how high the courts set the bar for this, look at the 1932 case of Bell v. Leverbros. The corporation decided to close down a subsidiary, paying two senior executives substantial compensation to terminate their service contracts. After the money was paid out, the company discovered these executives had previously breached their agreements. Lever Brothers could have legally dismissed them without paying a single penny. The executives had genuinely forgotten about their prior breaches when they signed the termination deal. Because they hadn't actively lied, Lever Brothers could not sue for misrepresentation. Their only legal route to recover the massive payout was to argue the settlement was void for common mistake. The House of Lords rejected the claim and upheld the contract. They established a strict boundary. There is a profound difference between a mistake regarding the very existence of a subject matter and a mistake regarding its quality. This balancing scale illustrates the court's reasoning. Both parties knew they were signing a termination agreement. The fact that Lever Brothers overpaid for it was merely a mistake about the value or quality of the deal. It did not cross the threshold into fundamental impossibility. When analyzing problem questions, remember that mistake is a doctrine of last resort. It fails against mere differences in value or profitability. A common mistake claim requires the subject matter to be entirely destroyed or non-existent, like agreeing to buy a car that, unknown to both parties, already burned to the ground. Making a terrible business deal does not destroy the consensus of the agreement. The second category is cross-purpose mistake. Here, the parties use the exact same terms, but possess completely different, equally valid interpretations of what those terms mean. The defining case is the 1864 dispute, Raffles v. Wickelhaus. The parties agreed to a contract for the sale of cotton arriving on a ship named the Peerless, sailing from Bombay. The buyer expected a shipment arriving in October, but the seller intended to deliver via a shipment arriving in December. Unknown to both parties, there were two completely different ships named Peerless operating out of Bombay months apart. This dual timeline illustrates the objective legal test applied by the court to resolve the ambiguity. They asked if a reasonable, neutral observer could look at the contract and determine which specific ship the parties actually intended. Because the language was perfectly ambiguous, there was no objective way to pick the October ship over the December ship. The court ruled that no meeting of the minds ever occurred. When language completely fails to connect the parties' intentions to a single objective reality, the contract is voided for cross-purpose mistake. Our third category is unilateral mistake, where only one party is operating under a fundamental error. In practice, this almost always involves a mistake regarding the true identity of the counterparty. The 1878 case of Cundy v. Lindsay establishes the baseline rule for fraud conducted entirely through written correspondence. A fraudster set up a business on the same street as a highly reputable company called Blenteron & Co. The fraudster ordered goods via mail, deliberately forging signatures to mimic the reputable firm. Because this transaction happened exclusively in writing, the court relied strictly on the physical text to determine the supplier's true intent. The court concluded the supplier intended to deal exclusively with the known, reputable entity they named on the paperwork, and absolutely not with the anonymous rogue who intercepted the delivery. The identity of the buyer was of vital importance. Because the supplier was mistaken about that identity, the contract was void from the start. Title never transferred, meaning the subsequent innocent buyers had to return the goods. In written transactions, the physical separation between buyer and seller forces the court to rely on the document. This allows the law to strictly enforce the intended identity over the actual recipient, protecting the original owner. This brings us back to our opening scenario, handing your car keys to a fraudster standing right in front of you. We find the legal resolution in the case of Lewis versus Avery, where a plaintiff agreed to sell his car to a man physically standing in his driveway. The buyer claimed to be Richard Green, a well-known television actor, and wrote out a check under that name. To seal the deception, the fraudster produced a forged official Pinewood Studios pass featuring his photograph and the actor's name. Convinced, the seller handed over the car, and the fraudster sold it to an innocent purchaser before the check bounced. The court applied a powerful common law presumption. When you deal with someone face-to-face, the law assumes you intend to contract with the flesh-and-blood human being physically standing in front of you. The seller wasn't truly concerned with the buyer's strict identity. He was concerned with the buyer's creditworthiness and ability to pay. Trusting the fraudster's wealth is a mistake of attribute, not a mistake of identity. Because the error was merely about an attribute, the contract was legally formed. It was voidable for misrepresentation, but not void for mistake. Therefore, the innocent third-party purchaser gets to keep the car. The second major pathway to a void contract is illegality. A contract can be illegal the moment it is formed, or it can become illegal based entirely on how it is performed. The law distinguishes between active culpability and purely incidental illegality. In St. John Shipping, a charter company transported goods but overloaded the vessel, causing the load line to sit below the water in violation of a statute. The cargo owner tried to avoid paying the freight bill by claiming the contract was performed illegally. The court reasoned that the statute was meant to penalize the specific action with a fine, not to invalidate the underlying commercial contract for carriage. However, intentional participation in an illegal act yields a different result, as seen in the Ashmore transport case. A company hired a fleet to transport massive industrial boilers. The transport company used lorries that could not legally carry the weight, and the plaintiff fully knew this. When the boilers were damaged in transit, the court refused to let the owners sue. By knowingly participating in the illegality, they forfeited their right to enforce the contract. Illegality also operates at common law, most notably through covenants in restraint of trade. If an employment contract restricts a worker from joining a competitor after they quit, that clause is prima facie void. Public policy dictates people should be free to earn a living. This flowchart illustrates the strict two-part test required to save a restraint clause. First, the employer must prove they have a legitimate business interest to protect, like trade secrets or a client base. If the employee is a standard worker, like a coach driver who doesn't possess confidential corporate data, the answer is no, and the restraint is immediately unenforceable. If the answer is yes, the employer must then prove the restriction is reasonable in its geographical area, duration, and scope of prohibited activities. Banning an executive from working anywhere in the country for 5 years is excessive, triggering the void state. Whether through statutory breach or common law policy, courts will systematically void agreements if enforcing them rewards illicit behavior or unreasonably restricts human capital. Rendering a contract void ab initio is an act of legal demolition. It is an extreme remedy reserved only for structural failures of consensus or legality. A contract is erased by mistake if the subject matter is physically destroyed, or if strict written fraud breaks the chain of identity. But face-to-face deception or inaccurate valuations leave the contract fully intact. Likewise, incidental regulatory fines preserve an agreement, but actively participating in illegal transport or drafting excessive non-compete clauses destroys it. When approaching problem questions, do not use the word mistake colloquially. Apply the strict legal tests to precisely separate void outcomes from voidable misrepresentations. Mastering these strict boundaries is essential. When commercial agreements collapse, these doctrines determine exactly who bears the ruinous loss.